My friend, today, many of us in the conspiratorium in our world were shocked to see the collapse of the indictments against James Comey and Tish James, aka Big Tish. And people are wondering, how did this happen? What is the story behind that? Well, let me tell you. The collapse of these indictments did not surprise any of us who understood the statutory framework and followed the facts of the case. Now, from the beginning, it was apparent, it was absolutely apparent, patent, that the prosecution was built on unstable ground and that the law, as written, would eventually assert itself. Now, Lindsey Halligan was installed as interim U.S. attorney on September the 22nd, 2025. But the interim authority found in Section 546 of Title 28 had already been exhausted by her predecessor, Erik Siebert. Follow this. That statute allows a single 120-day interim term, and that clock had already run. When Siebert refused to indict James Comey and Tish James, citing a lack of sufficient evidence, he was removed and Halligan was placed in his stead. The administration believed the new interim appointment could solve the problem, but the statute had already done its work. She arrived with no lawful authority to prosecute, which means every subsequent act was exposed to challenge. This was not a matter of opinion, but statutory fact, and I warned from the start that this defect could not be ignored or overcome. A proper reading of the law shows that when authority lapses, it cannot be revived, it cannot be resuscitated unless the statute allows it. And Section 546 clearly doesn't. That is why Judge Cameron McGowan Curry ultimately found the appointment invalid and dismissed the indictments. Not because he was a Clinton appointee, or no. It's because of the law, because of this thing called the Constitution. Now, the record shows that the Department of Justice attempted a cure after the damage had already been done. On October the 31st, AG Pam Bondi attempted to reclassify Halligan as a special attorney and backdate the designation to the date of her original installation. But by that time, Halligan had already presented both cases to the grand jury and had already signed the indictment. Authority to act must exist at the moment the power is exercised. That's axiomatic. It cannot be invoked retroactively. So the effort to backdate status, therefore, had no effect. So the indictments were created at a time when she had no prosecutorial authority. That's why the court ruled that she lacked lawful standing to indict either Comey or Letitia James. And the statutory limits were clear, and the government did not comply. Now, this kills me to see this, but it's the law. Now, the question now is whether the indictments ever legally existed in the first place, and whether they can be saved or resuscitated by Section 3288. That provision allows the government 6 months to re-indict, even if the statute of limitations has already expired, but only if the original indictment was valid and timely filed in the first place. So, Comey was indicted on September the 25th, and the statute of limitations expired on September the 30th because the alleged misconduct occurred during the Senate testimony given on September the 30th, 2020. If the court finds that an indictment existed at the time it was filed, then there may be a window to re-indict. But if the court finds that Halligan lacked authority and that no valid indictment was ever presented or approved, then Section 3288 doesn't apply. It can't revive what never existed. This is precisely what was predicted weeks ago. Seems like years ago. And a procedural misstep could become a fatal jurisdictional flaw. That consequence is now very much in play. Okay, there's also this. The question of how the grand jury presentations were even conducted. Halligan presented both cases herself and signed the indictments without using assisted U.S. attorneys or AUSAs. That choice could further damage the government's position. Why? Prosecutorial power is vested in the Attorney General, not in a flawed interim appointment, and it could have been delegated to properly commissioned line prosecutors or AUSAs. That would have insulated the cases. But Halligan chose to act alone, and that choice may have closed off every avenue for recovery. The defendants have filed additional motions to dismiss based on selective prosecution, failure to state a claim or a crime, rather, and the argument that no lawful indictment was ever filed. Now, those motions will soon be decided by the judges assigned to each case, and their rulings will determine whether the Justice Department has any realistic path forward. If the court finds that no indictment ever existed when the statute of limitations will not be told, and Section 3288 will not apply. Now, if the court finds that the charges fail to state a crime, that too will likely block any opportunity to refile or revivify. And if selective or vindictive prosecution is found, it could bar any further indictment entirely. So the Department of Justice, the DOJ right now, has to look at this. You've got to wait for these rulings before deciding whether to appeal Judge Curry's decision. Appealing now would be premature. The strength of any appeal will depend on whether the indictments are found to have existed in legal terms and whether the charges were properly articulated. Until those questions are answered, the DOJ, Pam Bondi, and President Trump cannot form a complete strategy. It must wait and watch the trial judges first. This case is not isolated. Similar challenges have succeeded in New Jersey, Los Angeles, and Nevada. Another one is unfolding in New York, where questions have been raised about interim authority and prosecutorial motivations and the like, I think regarding Tish James. In each matter, courts have found that interim appointments were stretched beyond statutory limits. Each time the result has been the same. The courts enforce the statute as written. This is becoming a broader pattern, not a single event. It tells us that federal courts are increasingly unwilling to tolerate improvisation with prosecutorial power. This is serious stuff. The Constitution does not allow the executive branch to bypass the Senate confirmation process without clear statutory authority. Section 546 provides a narrow exception, but only for a limited duration. Those limits must be obeyed. Once the 120-day period expires, the appointment cannot be extended unless the statute expressly allows it. Halligan's appointments didn't satisfy those terms. The administration tried to salvage its position by reclassifying her and then backdating the designation. As we say in the South, that dog don't hunt. That maneuver failed because the defect didn't lie in a label. It lay in the structure of federal power itself. Prosecutorial authority requires statutory grounding, and statutory limits must be respected. And where they are not, the indictments that follow are exposed to challenge. And the court found the challenge valid, and the indictments are now dismissed. Now, whether they can be revived or resuscitated depends entirely on the rulings that now await. Section 3288 can't do the work if it's found that no valid indictment ever existed. And the motions to dismiss must be decided carefully, and their outcomes will be shaped and will shape, in fact, the future of the case. If the case survives, it will do so despite the process, not because of it. Law punishes shortcuts, and this is one that finally snapped. The records now confirm what some predicted from the start, yours truly included. The statutory framework could not be stretched to fit the strategy, and the law held its ground. And prosecutions that relied on improvisation now stand in peril because the statute didn't bend to accommodate them. That is the story of this case, and it is the warning every prosecutor should heed. Now, watch this again if this seems a little dry, but it is not. The law depends on authority, on jurisdiction. And if you don't have jurisdiction, if you don't have authority, you are not able to pursue this, no matter who you are. My friends, I thank you for this. Thank you for watching our Lionel Legal channel. Please like this video. Subscribe. Hit that little bell so you're notified of live streams and new videos. And whatever you do, I ask you, my friends, and I have some questions for you coming up. Comment as you see fit.